Welcome viewers to another episode on Kirralie Smith, the law that changed women's rights, a Kirralie Smith investigation, the cost of legislative experimentation, when compassion became legislative assumption. Have you ever noticed how difficult it is to oppose a proposal once it's framed as compassion? Not because the proposal is necessarily correct, because questioning it begins feeling morally dangerous. And that's where many Australians found themselves before the 2013 amendments. The public conversation was not primarily about legal architecture, future conflicts or competing rights frameworks. It was about kindness, protection, inclusion, fairness. These are powerful moral instincts. Most people naturally support protecting vulnerable individuals from unjust treatment. The problem is that compassion can answer why something should be considered, while leaving unanswered how it will function once written into law. And that distinction matters critically, because legislation does not operate through feelings. It operates through definitions, boundaries, enforcement, interpretation, and eventually conflict resolution. As the amendments progressed, much of the national discussion focused on the immediate moral objective. If discrimination was occurring, protection should be expanded. If exclusion was occurring, barriers should be removed. Few paused to ask a more difficult question. What happens when future claims of inclusion encounter existing sex-based protections? The atmosphere surrounding the reform made such questions increasingly difficult to raise. And those expressions and concerns were often assumed to be opposing compassion itself, rather than examining legislative mechanics. The room became emotionally settled before the legal consequences had been fully tested. This is not unusual in politics. A compelling moral narrative often arrives before a comprehensive structural analysis. And the public sees the problem that needs solving. The future consequences remain largely invisible. Then time passes, courtrooms become involved, institutions begin interpreting definitions, policies expand, exceptions are challenged, boundaries are reviewed, and the theoretical becomes practical. The practical becomes contested. And society eventually discovers whether the assumptions made during debate survive contact with reality. A spoon touches a glass during a committee meeting. The sound seems louder than it should, and for a brief moment the room falls silent. Yet, perhaps the most difficult and most important question was already passing unnoticed. Was compassion being used as the beginning of the legislative conversation? Or was it quietly becoming the end of it? Because when compassion becomes an assumption rather than a starting point for examination, scrutiny often weakens precisely when it is needed most. And laws built upon insufficient scrutiny rarely remain uncontested forever.